California just passed 3 laws that could completely change gun ownership as we know it. One of them literally bans an entire brand of handgun. We're talking about Glocks here, guys. But here's the kicker. Criminals won't be affected by a single one of these laws. Only you will be. And Governor Newsom, he's got until October 24th to decide whether to sign what could be the most restrictive gun legislation we've ever seen. The clock is ticking, and what happens next will shock you. Look, I know what you're thinking. Another California gun law? What else is new, right? But this isn't just another feel-good piece of legislation. We're talking about 3 bills that fundamentally change how you can buy, own, and store firearms in the Golden State. I've been digging into the details of SB 74, AB 1078, and AB 1127, and trust me, the devil's in the details. We're going to break down exactly what each of these laws does, when they take effect, and most importantly, what your options are if you live in California. By the end of this video, you'll understand why even law enforcement gets a free pass while law-abiding citizens get the shaft. And I'll show you the timeline that could make or break gun rights in America's most populous state. Before we dive in, I need to be crystal clear. I am not an attorney. This is not legal advice. This video is for information and entertainment purposes only. Always consult with a qualified legal professional in your jurisdiction for any legal questions or concerns. If this information is valuable to you, hit that like button and subscribe. It helps more people find content like this when they need it most. Here's what most people don't realize about these 3 new laws. They're not random. They're part of a coordinated strategy to make gun ownership so complicated, so expensive, and so restricted that regular people just give up. Let's start with SB 74, the barrel registration bill. This one's flying under the radar, but it's potentially the most dangerous. Under this law, you'll need to pass a background check just to buy a replacement barrel for your firearm. Think about that for a second. A piece of metal tubing now requires government permission. But here's where it gets really insane. They want you to register every barrel you own. We're talking about creating a database of every single barrel in California. Why? Because barrels have unique markings that can be traced to specific firearms. This isn't about safety, it's about tracking. The law enforcement carve-out? Of course they're exempt, because apparently police officers are immune to whatever dangers these barrels supposedly pose to public safety. Now let's talk about AB 1078, the law that brings back the 3 guns per month rule. Here's the thing that'll make your blood boil. The 9th Circuit Court of Appeals literally just struck down California's previous attempt at this exact same restriction. They said it was unconstitutional, period. So what does California do? They pass the exact same law again, just with slightly different wording. It's like they're playing constitutional whack-a-mole, hoping the courts won't notice. Under AB 1078, you can only purchase 3 firearms every 30 days. Doesn't matter if you're a collector, a competitive shooter, or just someone who wants to exercise their constitutional rights. 3 guns, 30 days, that's it. But wait, there's more. The law includes exceptions for law enforcement, licensed dealers, and certain government officials. So if you wear a badge, you get unlimited access. If you're a regular citizen, you get rationed like you're living in Soviet Russia. The most frustrating part? This does absolutely nothing to stop criminals. Gang members aren't walking into gun stores and filling out 4473 forms. They're getting their weapons through straw purchases, theft, and the black market. This law only affects people who follow the rules. But the crown jewel of California's anti-gun agenda is AB 1127, the so-called Glock ban. This law doesn't just restrict certain features or limit magazine capacity. It bans an entire category of handguns based on their design. Here's how it works. If your handgun can accept a magazine that holds more than 10 rounds and it has certain cosmetic features, it's now illegal to sell in California. We're talking about some of the most popular and reliable handguns ever made: Glocks, Smith & Wesson M, NPs, Springfield XDs, all potentially banned. The really twisted part? This law takes effect in less than a year. That means if you want one of these handguns, you've got maybe 10 months to buy it before they're completely eliminated from California's approved roster. And guess what? law enforcement is exempt from this ban too. Police can still buy and carry these dangerous firearms that are apparently too unsafe for civilians. It's almost like they know these guns aren't actually more dangerous. They just don't want you to have them. The technical language in the bill is deliberately vague, which means it could be interpreted to ban almost any modern handgun. When lawmakers write laws this broadly, it's not an accident. It's a feature, not a bug. So here's where we stand right now. Governor Newsom has until specific deadlines to sign these bills. SB 74, barrel registration, must be signed by October 17, 2025. AB 1078, 3 guns per month, must be signed by October 23, 2025. And AB 1127, Glock ban, must be signed by October 24, 2025. But here's the catch that nobody's talking about. Even if Newsom doesn't sign these bills, they still become law. California law says that if the governor takes no action within 30 days, the bill automatically becomes law after an additional 12-day period. So Newsom has 3 options: sign them, veto them, or do nothing and let them become law anyway. Given his track record and his likely presidential ambitions, the smart money says he signs all 3 before the October 17th deadline, probably with a big press conference and a bunch of activists cheering in the background. Remember that Sean Ryan interview where Newsom tried to sound moderate on guns? Where he said he's not anti-gun at all? Yeah, that was all theater. These bills prove what we already knew. It was just an act for the cameras. The legal challenges are already being prepared. I've spoken with sources at several Second Amendment advocacy groups, and they're ready to file lawsuits the moment these bills are signed. But here's the reality. Litigation takes years, and in the meantime, these laws will be in effect. That means California gun owners are looking at years of compliance with unconstitutional laws while the courts slowly work through the appeals process. And even if the laws are eventually struck down, the damage will already be done. Businesses will have closed, people will have moved out of state, and the chilling effect on gun rights will be permanent. This is the playbook. Pass laws you know are unconstitutional, enforce them for years while they're tied up in court, then pass slightly different versions when they're struck down. It's death by 1,000 cuts. Look, this isn't just about California anymore. These laws are beta tests for what anti-gun politicians want to implement nationwide. If they can get away with banning entire categories of handguns in the nation's largest state, what's to stop them from trying it everywhere else? The Second Amendment isn't a second-class right, and it's time we stop letting politicians treat it like one. These rights existed before the Constitution, and they'll exist after it, but only if we're willing to fight for them. If you found this breakdown helpful, smash that like button and subscribe for more updates on this story. And when you're done here, check out one of the other videos on the channel. We've got plenty more content covering your constitutional rights and how to protect them. The fight isn't over, but it's going to take all of us to win it.